Hi, and welcome to another edition of the Trustcast Show. We're really happy to have with us today Joey Comley. Welcome to the show, Joey.
Thanks, Zane. I appreciate it, man. It's my pleasure to be here. Looking forward to it.
So, Joey spent 20 years as an Army officer, first as a field artillery officer commanding troops in combat, then as a judge advocate who prosecuted and defended over 100 cases and eventually wrote the playbook for military criminal jurisdiction across the entire European theater. Joy, when a soldier gets that knock, whether it's CID showing up after PT or a command pulling them aside to hand them an Article 15, what's the very first thing running through their head that gets them in the most trouble?
Zane, I'd love to say that, the answer to that question is different if it's a civilian whose door is being knocked on at their home and it's the local sheriff's department or local PD. Um, but there's really no difference in terms of what's going through their head. What's going through their head is um, number one, the truth will set me free. Um, Unfortunately, that's just not the case when you don't know the truth that the individual who's come knocking is operating under, right? So we all know these days everyone wants to claim they have their truth. Well, in no context is that more true than in the context of a criminal interview, right? So the law enforcement authority has their version of the events that they believe have taken place. And the interview with you, if you're the subject or the suspect, is very much geared towards validating their, preliminary conclusions. So to all of them, the truth will not set you free. Please exercise your right to remain silent and your right to an attorney. And I can't be more serious about that. That every attorney that you've had on your show, if they've ever represented individuals in criminal context, would agree that it is much more difficult to represent someone after they've already made a statement to law enforcement.
Yeah, so I had on somebody a character the other day, and I forbade him from using certain words, but he wanted to say "shut the f up."
I only say that when we're being recorded in an interview and I'm with my client. I had a client, Zane, one time, and he was being interviewed by a joint terrorism task force. So you've got representatives from ATF, FBI, the local sheriff's department, which at the time was San Bernardino County out in California. And then obviously military criminal investigators from US Army CID. And, as he's answering questions, I had already covered with him what I thought was permissible. I'd covered with the investigators what I thought was a reasonable scope to satisfy, answers to their most damning questions for my client. We weren't going to ad lib, we weren't going to fill in the margins. And I had to physically assault my client or batter my client on no less than 4 or 5 occasions. And I did have to say, shut the F up. So, yeah, that happens sometimes, unfortunately.
So you're a field artilleryman before you ever even went to law school. What made a combat arms officer decide, hey, I'm going to be a lawyer?
So, it's funny, Zane, my seventh grade English teacher, who was also my, 11th grade English teacher, had us bury a time capsule in 1993. And she dug it up, whatever that was, I think 25 years later, and shot me a note and said, "Hey, I'm glad to see you're doing exactly what you thought you would be doing in seventh grade." I said, "I want to play football as long as my body allows me to. And then I want to join the army. And ultimately, I want to be an attorney." So I've known I wanted to be an attorney for a long time. How and when I was going to get there, I had no idea. I joined the army because my brother suggested that I take an ROTC class in law school. And I did it. And then I realized one morning that they would pay me a monthly stipend. And the only thing I had to do was take one additional course. I had to exercise in the morning, which I already did. And I had to go shoot guns or march long distances with heavy packs once a week. I was in on that. So I took a scholarship, which helped me gain freedom from my father, right? So I'll never forget the feeling of coming home that first summer and my dad asking where my grades were. And I said, Dad, you don't get my grades anymore. And he said, well, why is that? And I said, you don't pay for anything, Dad. You're not entitled to that information. If I want to share, I'll share. But otherwise, just know that I'm headed back to school. So they're good enough that they didn't send me packing. But I took an ROTC commission into the field artillery. Ended up, my first duty station was in Europe. So it was absolutely amazing. I was in Schweinfurt, Germany with 1-4 cavalry, and got to deploy once with those soldiers to Iraq. That was Operation Iraqi Freedom 2. So that was from 2004 to 2005. I came back. I had the pleasure of working with a true scholar soldier in Colonel Chris Kalinda, and we redesigned that cavalry troop into a light airborne reconnaissance and target acquisition squadron. So it was the Army's first. Anytime you design an organization and its mission and its equipment and its people, that's truly a very liberating experience for someone, especially in the service, because you very rarely get to exercise creativity and artistic liberty in a bureaucracy. That should come as a shock to absolutely no one. But we got to do that. And then in the course of doing that, I was training and readying to deploy with those guys to Afghanistan. And I put in a funded legal education packet application. And my boss at the time, he's like, oh, I've applied for this 3 times and didn't get it. My LSAT scores 1 off of perfect. You don't have a shot, Joe. And I said, Jim, with all due respect, you shake a hand and you're clammy. You have a hard time talking to people and relating with anyone. So I have to imagine that your interview score was rather low, despite your stellar LSAT score and your amazing class ranking at West Point. So anyhow, I got accepted and then went to law school thereafter. And as a part of that program, you go to law school for 3 years. It's tremendous, Zane. You get paid your full captain's salary, and your job is simply to go to law school and do well, be an ambassador for the Army while you're there. And then in the summers, I had to do on-the-job training with the JAG Corps. So my colleagues called me the professor because I drove a nice 3 Series and dressed nice while going to law school. In exchange, I took them to lunch, a nice lunch downtown every other week on Thursdays. So
That is
that's,
pretty sweet. All you had to do in advance was have people shoot at you as an artillery guy, huh?
yeah, that's what I signed up for then. So,
Yeah. So, so tell me, what's a typical client look like to you, and how do they find you?
Zane, I wish I knew what a typical client looked like. They're really all over the map. I am a one of one at my firm, and I designed it that way purposefully. I got extraordinarily tired of kind of living in the standard operating procedure and mechanical workflows that you have when you're training up echelons of attorneys with varying experience and varying skills. So I do all the work in my firm. I do all the intake. I do the books. I reconcile my trust account. I file away cases when they're closed. I do everything. And I love it that way. So clients that come in, they can be neighbors that I run into when I'm walking the dogs, right? That was one trust and estate client. It can be folks that I work with on a Nolan River Wildlife is a wildlife rescue and rehabilitation nonprofit. And I did a dog bite for them. I did a farm lease for another one of the board members. I do tons. The overwhelming majority of my clients typically come across me in some form of media, or they visit my webpage or something else, or they're related to or friends of someone I've formerly represented, and they're having an issue in the military with respect to a security clearance investigation or, unfortunately, military criminal prosecutions and investigations. But I mean, I took one individual right of action, a whistleblower retaliation case out of the Department of Veterans Affairs, won that. And, fortunately or unfortunately, those matters are public. So once that public record posts of the proceedings and the results, well, then your phone starts ringing off the hook if you do well. So I've been blessed by success. And, Zane, I think any attorney would be lying if they didn't say that's the result of, just good clients coming into their lives. And that's what I've had. I've had an abundance of people who were sincerely and tragically wronged, either by their employers or a system or some agency within the government. And they've called or come across someone who knows me and been referred this way. So my advertising budget is zero. And I talked to a friend the other day and they said, how do you do that? And I said, I don't know. But the phone keeps ringing. The queries keep coming through the webpage and I keep getting emails. So I don't plan on changing anything and spending money unnecessarily anytime soon.
So I have written down here, and maybe I should have expanded this out. Military criminal defense attorney. You're more than just doing that.
That's correct.
Obviously.
That if I had to describe a specialty, that would be accurate, Zane. Other things that I take on, I am very honest with potential clients, and I'll tell them, like I have so many times now since starting the firm in 2022, hey, I've never done that, but it sounds intriguing. I'm willing to learn, and I'd love to do it. If you trust me, I guarantee you I can meet the minimal standard of competency. Right?
So have you taken a lot of cases to trial? I imagine as a military criminal defense attorney, you've been in a courtroom more than once.
Yes. Yes, I have.
So that usually gives some unique perspective. So when you had the dog bite, now I'm just kind of curious, does being able or willing to go into court, does that change things when you're talking about settling with another attorney, or do they even know?
I think when your opponent knows that you're not intimidated by the courtroom or interactions with the judicial branch of government, I think it sets you on at least an even plane with some of the big firms that you'll encounter, especially in private practice. I think the other thing that lets people know, hey, you mean business, is that you're just open with them. You're willing to reach out and talk to them early and often and professionally. And, you don't take bait that gets thrown your way, whether it's an early yet unreasonable settlement or it's a poke, right? Attorneys have huge egos. I'm sure that's no surprise to you, Zane. You've interviewed tons of them. And perhaps, unfortunately, had to utilize them from time to time. But I think a lot of times they'll poke at one another and they'll do so in an attempt to kind of gauge that person's, I guess, just their willingness to stoop to that level or be distracted by a personal slight. And I think when you show that you can rise above that and remain kind of the consummate professional in the room, that you get an immense amount of respect, and all of a sudden, a professional enters, assuming that the people you've been dealing with have been, the John and Jane assigned to the case. I think that happens a lot in private practice. I get the initial encounter is with a couple of counsel who got distributed, the case from Mr. Smith. And then, 3 months into this, after we've beaten back a motion to dismiss, we've engaged in some discovery. The motion for summary judgment went my client's way. All of a sudden, some managing partner calls and they want to talk about my settlement offer. So
let me ask you a few questions about the military. So what percentage of your business, Joey, is now military criminal defense?
So as far as the firm operation goes, because I also run the durable medical equipment company, the firm gets probably 80% of its business is either military criminal representation or it's related to a government investigation, typically a federal government investigation.
Okay. So I had because I have a bunch of questions about military criminal stuff, and I didn't want to go off on a bunch of off base. So okay, so a morning the soldier finds out they're under investigation. What are the 2 or 3 moves that will, I mean, if you could narrow it down that far, that is going to determine what direction their case is going to go in?
So the first thing they can do, like we talked about initially, is just let the investigator or the command representative, who is by title an investigator, they're just an appointed one as opposed to an assigned one. Let them know, hey, you're willing to make a statement. You want to, bring to light the whole truth, but you're only willing to do so after you've had the chance to talk to an attorney. And then what they need to do is reach out. All of these folks who are in the military, they have access to free legal counsel, whether that is legal assistance for some, or it's trial defense services, so trained criminal defense attorneys in other cases, and they can get basic advice, right? And I encourage all of the folks I interact with to take advantage of those free legal resources. And it's only to the extent that they're dissatisfied with some of that advice, or they don't feel like they're getting complete representation, because unfortunately, Zane, in the Army, and the Army is not unique in this regard, so many of the offices that would supply you with legal counsel will give you limited representation while you're just a suspect. That limited representation will kind of just briefly counsel you on your rights, but they won't take any proactive steps to contact the investigator, to contact the command and say, hey, I need to know what you guys are looking into. I got to know more than what you put on the rights warning waiver. What are we dealing with here? And kind of unpacking it and establishing a relationship. Hey, I know your job as an investigator in the military. Your job is to actually find the truth. And if you're doing that, then you're working for my client just as much as you're working for the complaining party. So if I can find a willingness in the investigator to work towards the, unvarnished and objective truth, then obviously I can do a lot of things that a, appointed military defense attorney just can't do, and is not resourced to do, and probably is not willing to do. So number one, it's exercise your rights. Number two, it's make a conscious decision on whether or not you're going to go forward with the free legal advice that is appointed for you, or you're going to seek out and at least examine any benefits of private counsel.
So I have an interesting question, because you said something there. They're interested in pursuing the truth. So I talk to attorneys all the time. So I've talked to some attorneys that really have the opinion, and I've talked to some people who've fallen under prosecutors that feel like that in some cases that they're not after the truth. They have a preconceived notion of whatever happened, and that if the truth gets in the way of that, they want to get rid of it. Is it different with the military prosecutors?
I would tell you, Zane, that, it differs from prosecutor to prosecutor. And I think it's largely a function of the leadership within that office, right? So every prosecutor in the military has what's called a chief of justice, right? And think of that chief of justice like the district attorney. So the district attorney can set internal kind of programs and policies that shape the prosecutorial approach, the zeal, if you will, of that prosecutor as an individual. And I think, that coaching, teaching, and mentoring that takes place within that office truly helps shape the measure of justice that is achieved in any particular case, whether it actually goes to trial or it is simply the advice that that prosecutor gives to the investigators as they're developing the investigative product, right?
So I want to make one statement here, just, and then I have some other questions. Anybody who's listening to this, I did not just impugn all prosecutors. There was just a small group of prosecutors. So don't throw me under the bus.
No, Zane,
So
I trust me that I have worked with prosecutors that I have spoken to outside of the presence of the jury and the judge and said, "Hey, you really want to take this to trial? Look, you've got this and this and this and this. It's going to be embarrassing. And I'm only telling you this because I've had to take weak cases to trial. Some of those are deserving to go to trial, even though they're weak cases, because you've got, a victim who truly suffered harm, but you are missing some of the expected objective elements of evidence that everyone who's watched any TV show where they all get solved in a half hour or 45 minutes or an hour, they're going to expect to see and they're not going to get. So I think I've had those conversations, and then I've had the other ones with prosecutors where they'll call me, and this actually happened in the military, and the prosecutor said, "Hey, after the preliminary hearing, when you presented all that evidence, I don't have probable cause anymore, which means ethically, I'm not going to pursue this case. So I'm resigning from the case effective today. I just want to let you know, I think your client's innocent." And I said, "Thank you." Now, unfortunately, the Army still prosecuted that case all the way to trial, and the judge rendered a verdict. We did a bench trial, no panel, which is the military jury equivalent. The judge decided the matter without deliberations from the bench. As I'm arguing, he started packing up his things. And I realized in that moment, wow, if this is going to go against me, I've got to set this up for appellate error. So I said, "Your Honor, I can see that you're tired of listening to me and you've already made up your mind. That being the case, I'll go have a seat." And he didn't even let me get to my chair before he said, "Defense counsel, remain on your feet. Accused, please rise. This court finds you of all charges and their specifications not guilty."
that's a pretty smooth move on your part. Just went up the. So it's interesting. So if a soldier gets I'm just kind of curious too. Can military police, can they lie like regular police?
Oh, yeah.
Okay. So if I get offered an Article 15, I'm a soldier, I'm offered an Article 15, and then I'm told, well, this is actually the best thing for you. This is good. This is really what you want to do because this is going to protect you. Am I missing something?
All right. So you're now Sergeant Myers and you walk into the office and you've got an Article 15. The great thing is the way the Army works is they force you to go to trial defense services if you're getting an Article 15. So you get read your Article 15 just like you would, charges in the civilian world. You're getting arraigned at that point in time, but you're getting arraigned for this, paper reprimand that has some consequences. You take that piece of paper and the quote unquote evidence that supports the charges on that Article 15, and you go into trial defense services. You're going to have to watch a video. You're going to have some questions typically answered by a paralegal. And then if you still have questions, or you ask questions that paralegal knows, hey, that's going to entail legal advice, you can meet with an attorney right then and there. So when you meet with that attorney, I guarantee you the number one sort of question they're looking to get an answer for is, do you want to roll the dice? If you're not guilty, I cannot advise you to accept the Article 15. I can simply tell you, look, these are kind of the benefits of, taking this Article 15. The other thing you can do is you can call the command. I would call the prosecuting attorney and the command sometimes and just say, hey, look, this kind of looks like you guys just have to do something. Like, what do you intend to do by way of punishment if my client comes back, he owns this issue, and he tells you, look, whatever you do, just don't take my rank. Let me walk out of here as Sergeant Myers. You can restrict me. You can give me some, hard labor. You can give me some extra duty, all those sorts of things. And they'll say, yeah, that's all we want to do. We've got to do something here, but we're not looking to make, Sergeant Myers, PFC or Specialist Myers. We want to see him continue to lead soldiers. We think he just made an error here. And unfortunately, his error is punishable by the UCMJ. So I think when you have kind of those open conversations, you can get to a reinforcing kind of end result that truly substantiates that statement that you started with, that, look, it really is in your best interest sometimes to just take that Article 15, learn from it. And guess what? The Army is no different than any organization, in that history repeats itself. When I was a combat leader, if my NCOs didn't have at least one Article 15, they couldn't be trusted. So,
Well, usually I think of an Article 15 as a former soldier myself as somebody getting busted down in rank, but that's not necessarily what happens.
correct. And I mean, that's when you saw the Article 15, because otherwise, unless you ask for, the proceedings to be conducted publicly, which I actually did that a few times, and I have soldiers do that when I was a troop commander. I think there's great value in that. If you really need to make an example in your community, in your formation of the misconduct that took place, wow, what courage it took for that young soldier to say, sir, I'm okay with you doing this in the motor pool. Awesome, right? And how impactful, not only for you in terms of your growth, but for the entire formation and for me as a leader to kind of convey, look, I'm rational, I'm reasoned, I'm measured in my approach, and it's transparent. So just like anything, Zane, if you can transparently demonstrate a justiciable kind of process and outcome, I think it just builds trust, faith, and confidence within the unit, in a way that you can't otherwise. And I think, to your point, you took them as, if you're getting an Article 15, you're getting busted down. Well, that's what you see. Your rank was on your chest or on your, collar. Your bank account balance wasn't. Your plans for the weekend weren't on there, unless you lived in the barracks and you saw them on like staff duty. or CQ at the brigade when you went to sign out and you were like, oh, yeah, you've been on this for a couple weeks now. And then, like something bad happened with that Article 15. But otherwise, the rank, I think, is the most obvious, punishment that is visible to everyone.
So Joey, when should somebody turn to it? So you talked about using, the free legal services within the military, which is great, but a lot of times those people may be stretched thin or may not have the experience. I'm sure you get assigned somebody similar to like in civilian where you don't have the money, but it's a little bit different in the military. But when should somebody look at stepping outside of the military and deciding, okay, well, I need private counsel. I need to hire private counsel.
So I tell everyone the same thing. I think it's after you've had that initial meeting with your appointed counsel. So again, assert your right to counsel immediately. Have that, initial meeting with your appointed counsel. And, as an individual, you have to make the call, hey, do I trust this person to represent my interest? Are they truly going to put me first? And if the answer is yes, then the second question you've got to ask is this person in a position that they can do everything I need them to do right now to maintain my innocence? And I think sometimes the answer is just no. They don't have the resources. They don't have the scope of representation that enables them to kind of reach out to certain entities at that point in time. So, and they'll tell you this. They're very transparent. Hey, these are kind of the rights you have as a suspect or a subject of an investigation. These are the rights you have as an accused. These are some things that I could do for you. I think an honest question that a military accused should be asking their, appointed counsel is, hey, what is something that's beneficial that you cannot do for me?
So, security clearance investigations, they're separate from criminal cases. How do these two processes interact? Can a soldier lose security clearance even if they're acquitted?
So what happens oftentimes in investigations and in any sort of adverse action, be it administrative or, punitive under the UCMJ, service members will have their security clearances either suspended or at least the security manager will be notified of the ongoing issue. So sometimes those processes can operate in a vacuum. Other times they're largely dependent on the resolution of the administrative action, the investigation, or the prosecution. But I can tell you that it's extraordinarily rare for someone to be prosecuted for an offense, receive a conviction, especially one involving a punitive discharge, but to maintain their security clearance. I would say that's extraordinarily rare, but that's at one end of the spectrum. The other is there's a command investigation. The commander's done due diligence, exhausted all of the leads, and, has suspended temporarily a security clearance and then notifies the security manager upon the conclusion of the investigation that was resolved favorably. Hey, no adverse findings. You're not flagged anymore. They let the security manager know, hey, this has been resolved. It was resolved favorably. I think that in that sort of instance, it would be extraordinarily rare, just like the other person to maintain their security clearance, for that individual to lose their clearance. And then there's everything in between. And I think it's the everything in between that those folks really need to get someone who's experienced with, DISCA investigations and adjudications and then appeals from them to administrative judges who review their decisions. And, if your counsel has never done that, who you're working with on your appointed side of the case, you really need to reach out to outside counsel. because
Okay, you want go ahead. Go ahead. So
I
you
mean,
want a sharp case. Do you want to finish that thought? Because I was stepping on what you were saying. Sorry about that.
no, I was just saying you're in the greater Seattle area. You know, and you've seen how important, maintaining a security clearance is for many of the military professionals as they transition into civilian employment. If you take that away, you take away 20 to 30% of their annual earning potential. So there are tremendous costs that come with people losing their security clearances. So it's not something that people should just kind of, roll the dice on. Go ahead. You're talking about a sharp case.
A sharp case, a sexual harassment or assault case, you described as one where your client was actually the victim of the system's misuse. Can you take me into that case?
Sure. I wish it was just one, but it's not. I can take you into the most recent one. So that service member had a complaint of sexual harassment, but it was sexual harassment that, according to let's just say the alleged victim said that there was touching involved in the complaint of sexual harassment. So when that happened, obviously you've got command investigators looking into the sexual harassment. You've got them saying time out, and then they pass the touching over to CID. So then you've got CID coordinating now with the Office of the Special Trial Counsel, which is, just stick around, Zane. They'll create a new acronym, and Congress will fund a new program to experiment with, sexual harassment, assault response prevention, which they did in this case. So all these things come down unfavorably for my client. And this is a client that was transitioned to me late in the game. And it was transitioned to me by an attorney who went back on active duty. So he was a civilian practitioner in the reserves, went back on active duty, so he couldn't maintain the case. So he passed the client to me. The client hired me. And as I'm looking into it, I'm recognizing these names. And I recognize the alleged victim as the alleged victim from yet another case that I had. And in that case, the investigation was resolved favorably because I was able to present all of this evidence that impugned the character for truthfulness of that alleged victim. And some of that evidence included that she had in fact said, hey, I know how to get any leader removed from my supervision. I just file a sharp complaint. It's worked for me in the past.
Wow.
So, needless to say, that client issue was resolved favorably. This one was also resolved favorably. But Zane, as a former soldier, you'll appreciate this. He was a National Guardsman, so they did his board procedure to try and revoke his federal status, right? His withdrawal of federal status. That was resolved favorably. They said retain him. Then I had to go back, get all of those board members to write separate statements about how they didn't think that the actual GOMAR that existed was supported by any evidence. Then I had to go back to the Mississippi National Guard. Mind you, this soldier's in the New York National Guard. I had to go back to the Mississippi National Guard that he deployed under, and they reconsidered the 15-6 and arrived at different conclusions and said, hey, the 15-6 that substantiated the GOMAR is no longer supportable by any evidence. Now you've got all that, and you would think the system would fix itself, right? Wrong. So the system still didn't fix itself, and we had to file special consideration back through the Department of the Army Suitability Evaluation Board, DASEB, and that is still pending. But it's got the concurrence of the New York tag. It's sitting on the chief of the National Guard Bureau's desk, waiting for him to rubber stamp it. You can't do anything when you have objective reality saying there's no evidence to support that he did anything wrong. In fact, the greater weight of the evidence supports that he did everything right and that all of this was a lie. So the beautiful justice in all of this is that that alleged victim, three-time alleged victim, has now been separated from the Army, largely in part to how she handled herself as an NCO.
You would think that that would settle it, as her actually being. So you have to say what a GOMAR is, because people who are listening are not going to know what that is. Sorry.
It's a general officer memorandum of reprimand. I try not to speak in acronyms, but
it's
it
bad
definitely,
juju.
yeah, it means, imagine, so if you're in corporate America, if the CEO writes a bad letter upon your termination that follows you in your employment file wherever you go. That's essentially what a GOMAR, or a general officer memorandum of reprimand, does.
So we have to ask about one thing. Are we? I've saw this little. Okay, so it's just I have to ask about one thing. So the military criminal jurisdiction for the European theater, is you designed that with your chief military justice at V Corps. What does that mean? Why did the Army need it? How did they pick you out to do it? How did you, or were you a military volunteer? And I'm just curious. When I read that off earlier, then it got my brain going. What Joey? What is all this?
I was a legislative counsel for the Army, which means at the time I was in the Pentagon and I worked for the Office of the Chief Legislative Liaison. And my portfolio was specifically Army operations, support to America's nuclear enterprises, and the authorizations for the use of military force. Well, under the panoply of Army operations was essentially anything that the chief of staff and the secretary wanted to do. Well, at the time, the secretary wanted to grow the Army. And in growing the Army, he wanted a new corps, right? So that would have been numerically the fifth corps for the Army, because it had four at the time. And he wanted it specifically to control European operations. Well, V Corps, or Fifth Corps, was stationed in Europe, in Germany, for the longest time. And so we decided, hey, let's just resurrect it. Well, at the time, it was debated, hey, where should we best house this corps that's going to be in charge of all of Europe's ground operations? Well, obviously Europe, right? So the Judge Advocate General for the Army at the time called me and said, hey, Joe, we want you to go be the Chief of Justice at this new corps, and we want you to design its jurisdiction because you've had some familiarity with doing this. I did this in Afghanistan when we set up a merged regional command South and Southwest. So we took the Marines in Helmand and we set up a new jurisdiction in Afghanistan. So I had some experience doing this in the past, and unfortunately that made me one of one at the time for the JAG Corps. So I got the job. It happened to be here at Knox, and there's no surprise as to why that happened. The Senate Majority Leader at the time was Mitch McConnell. So if the Army was going to grow, it was going to grow in his backyard, which is very much a political reality and kind of the result of, somebody being in power in a committee like the Senate Armed Services Committee. So long story short, the Army got a new corps. It was V Corps, and V Corps is headquartered in Fort Knox, Kentucky, exercising command and control for European forces.
Okay. So
Brilliant,
you're,
right?
yeah, brilliant. Our political system at work, which is brilliant, although it's also, it's both brilliant and idiotic at the same time. It's the most brilliant system in the world. So this is as close as I get to politics. but it's also the most asinine in the world. But I'll take the brilliance overrides the asinineness. So you came, you're actually from Kentucky, because we were talking about, I didn't realize you're actually from Kentucky, and you came back home after 20 years. What does it mean to do this work in the community you grew up in?
So here's the thing. I'm from, in terms of the blood running through my veins, Kentucky. I was born in Wheat Ridge, Colorado. I grew up between California and Mississippi. Um, and for years, I did what every soldier does. Um, I I resided wherever it was, advantageous from a tax standpoint, and would have lived there but for the Army's orders. So I intended to live there, but just couldn't. So I was, by all legal accounts, domiciled in these great places where I didn't have to pay state taxes, which was awesome. But no, I would always say, in response to the question, where are you from? American, because I really didn't have a home state. At least no place that I knew for sure. Whenever I retired, if it wasn't immediately, I was going to go back there. I was going to go wherever opportunity took me. Kentucky is my father's home. So
Okay.
my dad and several hundred years of Comleys are from um, a place called Garrard County, which should be Garrard County, but in Kentucky it's Garrard County. It is south of Lexington. It includes major metropolitan areas like Paint Lick and Nicholasville. Um, Obviously, I'm being facetious, right?
It's
Tiny small
a
town.
cultural bastion of cultural enlightenment.
Yeah. So I mean, at my core, there's a lot of Kentucky history in my family. My family split in the Civil War, fighting for Ohio in the north and remaining in Kentucky, fighting for the south. So the Comley family roots run deep in Kentucky, and it's really just a pleasure to come back and be driven back here by not only the circumstances of my professional career, but also in my personal life by the desires of my children. My children were raised, Zane, all over the U.S., from California to New York, and then 2 tours in Europe. And after living in Kentucky for 2 years, they came to my wife and I on the eve of us moving to California and said, "Hey, we love California. We love visiting our family there, but we've never been any place where the people are as nice as they are in Kentucky. We think it's a good place to grow up and we want to stay here." So my children are the reason I'm in Kentucky. And I have every reason to believe that, there's something that still flows through their blood and exists in Kentucky communities and in the average Kentuckian that you'll encounter. If you ever make it to the Derby, or if you come down and try your walk along the Bourbon Trail, I think you'll see it firsthand and just realize some of the kindest people you'll ever encounter live right here in the Commonwealth.
That's a nice thing. So, where can soldiers and families find you? What's the best way to reach out if they're in trouble or they think they might be?
Yeah, so it would be my webpage. It's www.thesoldiersadvocate, that's plural.com, right? So they can reach me through my webpage. I give an example in the potential client query of what to include and what not to include, because obviously I want to ensure that my client's information and their story are all protected. They can also call me at 270-360-0142. So
So, just out of curiosity, we didn't talk about this, but where can you practice? I mean, can you practice everywhere because it's a federal? I mean, not on obviously not on all issues, but as far as military, can you just practice
So
because
the
it's
UCMJ is a worldwide jurisdiction, and the requirements for a defense counsel is simply that they remain licensed and in good standing in the highest court of one of the states or a territory of the United States. right? So
Okay.
I'm licensed to practice by the highest court here in the Commonwealth of Kentucky and in Mississippi, which is where I went to law school and took the bar exam. So, but I've been a U.S. attorney with limited practice rights in New York and California. And then I've been admitted pro hoc in other states for, those particular cases. So,
Joey, thanks for coming on the show. I really appreciate it.
Zane, it was awesome. My pleasure.